I'd like to welcome everybody to the presentation today. It's called The Biggest Legal Challenges Facing the Subprime Industry, a View from the In-House Counsel's Office. And for this segment today, we've got three in-house attorneys from the automotive industry. I'll let them each give you a little bit about their background and introduce themselves, starting with Tiffany, right after I give you the legal disclaimer that we have to give for all of these kinds of presentations now. Even though we're going to be talking about legal issues, none of the information that's given today should be considered legal advice directly to you. The information is also the opinions of the panelists and not necessarily the companies that they represent, or should be applied in any way to be an opinion of NABD. So with that being said, I'd like to turn the introduction over to Tiffany Baker. She's with Car City, and she can tell you a little bit about her background and her experience.
Thank you, Robert. We're filling up. This is a hot topic today.
Everybody wants to hang out with us.
Yeah, exactly. Tiffany Baker, I'm in-house counsel at Car City, which is a lease here, pay here operation. We're in Michigan and Indiana, mostly in Michigan. We have 7 locations and obviously a related lease finance company. I've been with Car City for 4.5 years now, so I came in when everybody said, we need to do compliance. And before that, I practiced criminal law. So there are some similarities, actually.
Thanks. Evan?
My name is Evan Namias. I'm with City Auto Sales, which also has 7 rooftops right now. But David Andrews, immediate past president of NABD, is also in the auction industry, in the floor plan side of things. So we get a really great cross-section of legal issues relating to your business. And I've been with them since 2015. After leaving private practice for my favorite clients, them, in 2014, they started with them in 2008. And this is, appreciate you coming here. This is, we had a great conversation across the hall, and I'm not trying to jump the gun, but this is your board of directors. Y'all have met 5 good people here, and most of your problems, if you'll kick them around amongst yourselves a little bit first and then give a good lawyer a call, you'll be surprised at the great results. We've had a lot of great ideas exchanged this morning, and looking forward to this afternoon.
And last, Clay.
So Clay Scheidsock, I'm the general counsel at Drive Time, and I like this terminology of rooftop. So I'm new to the car space, been at Drive Time for about a year, but so we have about 150 rooftops across 27 states. And we have our related Finco Bridgecrest that services our loans as well. And we're excited to be here. And our goal today from this panel is not to scare the crap out of you all with all the problems and all the bad things that can happen, but hopefully give you guys some ideas and some takeaways that you can go back and implement.
Thanks. And my name's Rob Sickles. I'm an attorney in Tampa, Florida. I serve as the outside general counsel to the Florida Independent Auto Dealers Association, and I also represent about 400 automotive dealers in Florida, some in Georgia and some in Ohio. And I also represent finance companies and lenders involved with the industry. I'm the moderator today, so my job is to try to keep the lawyers on topic. Don't hold it against me if you can't, because anybody that has talked to lawyers for a while knows that's like herding cats. But we've got 2 broad areas that we thought would impact dealer operations, and that really this is kind of the focus of the panel for today. We're going to start with compliance issues. And just to throw it out to the panel, I'd like to have each of you talk about what you consider to be the #1 compliance issue that you're dealing with within the industry, and maybe a best practice for resolving that.
Tiffany.
Me first?
Sure.
Thanks.
You had all the good ideas.
Yeah. This is one of those like ladies first, right?
Right.
You go first. I think, well, one of the things I want to talk about was TCPA. I know that's probably on everybody's radar. I think that's...
The what?
Sorry, Telephone Consumer Protection Act.
Sorry.
Thanks. Yes. The TCPA, so this is what protects people when you're calling, using auto dialers and texting. So how many of you guys are texting customers? All right, so everybody who raised their hands should know about the TCPA. All right, I'm sure most of you do. I won't ask for a raise of hands on that. But I think that's definitely a big issue. It's a big litigation issue. We've been hearing about it for years, but I would say that that's something that I'm going to try and give the perspective on this panel a little bit more of, if you're a small dealer and you're coming here and you're saying, look, I need to know bare minimum, you know, I need to know what the first few boxes I need to check off. I'm going to try and give you guys that perspective, and I would say TCPA is going to be one of those, right? If you're going to go home and say, I got to handle my first compliance issue and write a policy, I think it's something you can bite off. It's something you can feel really good about getting that taken care of. It's doable, it's manageable, and you're going to save yourself litigation and compliance headaches. So that's going to be my hot tip for the day.
Thanks. Evan?
Well, and again, great discussion started this morning. We want it to keep going today. Tiffany made the observation earlier is you know, really it's you as business owners analyzing your risks. What are your risks? Your risks are dissatisfied customers suing you and the government saying you've done something that doesn't comply with the law. So one of the best defenses against government finding fault with your complying with the law is getting a basic grip on the laws that apply to your business. The TCPA, the Telephone Consumer Protection Act, is a big one, but it's no less big than the buyer's guide in your window. I would bet dollars to donuts that every dealer in this room is pretty attentive to the buyer's guide in the windows. The used car buyer's guide, Federal Trade Commission requires it. Easy penalty, per car penalty. You don't need those. That's an easy one, and everyone here is compliant in that regard. But the other issues from a compliance perspective would be more of a compliance management system, which again touches on what Tiffany was talking about, having a written policy. We don't expect you to necessarily publish a 50-page policy. Ours is probably closer to that 50-page, but I'm there all day, every day. I'm assuming most folks in this room don't have a legal department, but you can create that policy. You can, again, send it around with your board of directors to crystallize the ideas, and then it can be a half of a page. Your Telephone Consumer Protection Act policy can be something simple. It does not have to be notarized or you know, gold seal stamped, but having those rules, those expectations, and making sure your employees know what your expectations are, I think is a better recipe for success.
And how do those written policies also help in the event that a regulator comes in or you have some kind of an investigation?
Well, I think very much so that the fact that you think about these issues in advance, if a regulator comes knocking on your door, of course, we all want to be helpful. Look, the government is our government. It's our government. They work for us. They think they're doing the right thing. You think you're doing the right thing to talk with them. I would suggest have a relationship with a lawyer. As it turns out, there is a National Association of Dealers Council who are lawyers who do nothing but talk about the car business. That's one end of the spectrum, but a good, smart lawyer in your hometown is a great resource, and call that resource if the government ever comes in. That lawyer will then hold up your policy and say, our dealership has thought about this. We made this decision. Having those policies is the very first step of defense, in my view.
Yeah, there's also the risk there, right? So I just want to be clear when we're talking about having a policy. So you could call us, and I'd be happy to, we share policies, and you'll have your group. But if you're not doing what your policy says, now when that regulator comes and you say, hey, look, we had this policy in place, and they're like, that's fantastic, you did none of that. Right now you've essentially hung yourself with that. So be very careful. Policies are great, and I do think it's important to have shown that you've given that forethought. But if you're not going to do what your policy says, then there's a question of, you know, why have the policy in the first place?
Exactly. Sometimes you can download a form from the internet that says it's a red flags policy or it's a information security policy, and dealers just adapt it, put it on their letterhead and put it in their file. But it turns out it's actually, you know, a privacy policy for a company the size of Microsoft, and they talk about the encryption that they have and the password protections that they have, and none of that exists at the dealership level. Yeah. So, you know, make sure that what you're doing is actually compliant with what your policy says. Just because you have a policy doesn't necessarily, I agree, mean that you're complying with it. But you mentioned the federal regulators, and I'd like to get each of your thoughts on a recent article. There was an article that ran on October 3rd in law.com. It's a website for lawyers. Kind of, nobody would enjoy it. Don't go there. But the title of the article was a pro tip from FTC privacy enforcer. Don't make life hard on us. And the purpose of this article was an interview with an FTC regulator that talked about how his experience dealing with different lawyers really impacted how the investigation was done, and that lawyers that make life difficult on regulators end up causing more problems for their clients than lawyers that just simply cooperate with regulators. And I don't know that that's always the best strategy, because I've dealt with some regulators that overstep their bounds. But I've also dealt with some regulators that are really just trying to get to the bottom of what happened and cooperate. So I would go to the panel, and Clay, we'll start with you this time. Do you have any thoughts on the cooperation with regulators versus having to push back at times?
Yeah, I mean, here's the legal thing, right? It's how do you define cooperation, right? Like how I'm going to define cooperation and how that government regulators are going to define cooperation are probably two different things. Of course, you are always going to cooperate with the government. Let's be clear, you don't have much of a choice, right? The government shows up at your dealership, they're there with authority, and you're going to provide them, you know, reasonable data and responsive information. So I 100% agree with the approach that you don't want to go and just pick a fight for no reason. But I also agree with you need to be cognizant of what's being asked and why it's being asked, and what the consequence of you providing that information means. So be thoughtful about it. You don't just turn over all of your files to the government without an understanding of, you know, why that's being requested, or, you know, what the scope of the investigation is, and put some parameters around it. And Rob, to your point, there are regulators out there that will push their boundaries, right? And they will overstep their boundaries, and you have to be willing to draw that line of saying no. And there are times that you say no, do it in a polite, respectful manner, but you know, you may have to draw those lines, and those become a much more difficult situation, because that obviously can escalate, and they can use their authority in a punitive manner in some instances. So.
Okay. Now, would you consider taking a lawyer to the first meeting with the regulators, and you guys have a little bit of a different perspective because you're all lawyers, but if, say, one of your dealerships was getting a visit from the DMV, would you suggest that a lawyer be present, or that the dealer deal with it on their own? Or would it depend on the situation?
So from me, here's how I'll answer that. One, to the extent a regulator comes on our property, we want to know. Doesn't mean we say, oh, I can't talk to you, only our lawyer can talk to you. That's not the way we handle those matters, because we deal with the DMV on a daily basis. Like that's someone that we have a relationship with, and I want our folks to have those relationships. To the extent they're asking for information and the like, then they do kick those over to us. And so, yeah, I'm not going to say you always have to have an attorney by your side. I mean, I'm all for full employment of lawyers. I think that's a great thing. But that's not practical, right? So you have to be able to interact on a day-to-day basis with regulators. They're human people as well. You just need to understand what their motivations are.
Clay, I think a good red flag for you would be if you want documents. If they're asking you for documents, do yourself a favor. By the time they want documents, I can't imagine why you wouldn't want to have a lawyer involved.
Yeah.
So for us, the regulator that we would have come in is just our state. We're getting state exams, right? And that's probably the case for most of you guys, right? You're just getting your state exams once in a while. You probably have a process you're used to handling those. And it doesn't necessarily have to be something that you have an attorney there for if it's a process you're used to and you're used to that regular and they've been coming into your dealership for a long time. But I do think the areas where you do push back are what Clay was saying, when the scope of what they're asking for. If they ask for every deal jacket, everything you've ever done, you can push back on that, right? Ask them for what they need What do they need? How do they need to get it, right? So sometimes a state regulator, the diffs in Michigan, they'll, can we have direct access to your system? No, you can't, but we'll get those documents for you. So if you don't watch what they're asking for and how far they'll go as far as they can. But it doesn't necessarily mean that it has to be a contentious, bring your attorneys in. For a lot of people, it's just, you have your Secretary of State or your DMV or your Department of Insurance and Financial Services or whatever it is, and you have a relationship with them, and it's, something you're going to see them every few years maybe.
Well, there's also, I think, legitimate questions as to how the documents are going to be used, what's going to happen to them after the investigation's done. Are they going to be public records? Because if that's the case, there may be redactions that need to be made before that information is made available to the public. Many instances you might not want certain documents made available to the public. And I don't know how many of your deals include washout information or profit and loss on a particular deal, but certainly there would be no reason that a regulator would need that information. So to simply say they want all the deal files, I think, many times oversteps those bounds. But making sure that maybe you get the documents back or that there's some type of confidentiality protections in place. Now, some states can't do that because they have public records laws, but there's oftentimes carve-outs for investigative processes and investigative materials that are obtained during that process. And I really think when you're talking about customers' financial information, many times you'll be able to get regulators to agree that Social Security numbers can be taken off, income, information like that. So turning over everything may not always be the best practice. Evan, did you have another thought on that?
Well, only that even with the state regulator processes, I've looked at them.
Right.
As a lawyer, you've looked at them, and even within your own business, make sure you've read them. There's this an old adage, and you say it before every deposition. I hope no one in this room has ever been deposed. But every person who's ever been deposed, I've told them, when the other lawyer asks you what time it is, you don't tell them how to build a clock.
I don't recall.
Well, no, you listen to the questions, and so too, when the government asks you a question, make sure you're listening to the question and answering their question. And again, once it gets outside the lines of, this is my business information, this has nothing to do with what you're looking into, then you answer that question. But defining the scope and responding to the scope, I think, is a good thing to keep your eye on.
I think bottom line, you should all be on guard when someone from the government shows up and says they're here to help. You should be aware.
I think there's a coffee cup to that effect.
Yeah, that's right.
Well, besides attending panels like this one where you get this wealth of information, any of you have any other thoughts on staying abreast of the latest compliance issues or compliance topics? What resources are out there other than maybe going to a lawyer that's going to charge you a few $100s an hour? Is there any way or anything you guys do to stay up to date on those kinds of things?
Well, I tell you, in our earlier meeting today, I learned that the Florida Independent Auto Dealers Association at their quarterly meetings has their attorney up there and available. I like that. As far as dealerships go, coming to these things are invaluable. Again, y'all are the best in the game. You're the people who are smart enough that you could leave your business for days with the staff you left behind to come here and get your game better. That shows the type of commitment that leads to success. I think emailing each other, getting those business cards, or not, email each other, use the resource. But the Independent Auto Dealers Association is where you and I met, and we've been exchanging ideas since we met. So
which was 2 weeks ago.
That's right. But within 2 weeks, both of our companies have learned something that'll help both of our companies. So being active in your trade organizations, I think it's just, again, you're making your business better. It's a great investment.
Yeah, I think the only other thing I would add to that, and Evan mentioned it before, is you should be developing relationships now. And so find a law firm out there, or find a resource now. A lot of those places have free newsletters that they'll gladly send out to you. One of the biggest challenges we have, right, we're in 27 states, and trying to stay abreast of the changes in 27 different states is a daunting task. And so, it's hard enough to do that in one state. And so getting those types of newsletters, using the IADAs, and using the resources that are out there now, when you don't have a problem is the key, right? Doing that prevention now is what's critical so that you can avoid that problem on the back end.
I think, yeah, staying part of organizations, anything where you can have that peer-to-peer sharing of information, because nobody's really in the trenches like you are and knows what you're doing than the people that you're in this room with. So, you know, you're going to find the people by going to meetings and events and conferences. You'll find the people that you go, you know what, that person really knows what they're doing, and I'm going to pick their brain. And so that's going to be an invaluable resource. I'm going to give a shout out to Hudson Cook too. I think the realistic perspective of being general counsel is that when someone comes and asks me something, a lot of times I say, I don't know, but I can find out. And so, you know, things come across our desk, novel things come across our desk all the time. I'm sure that's true for all of us. So having a resource that you can reach out to and say, you know, hey, I've narrowed down the issue here and I've figured out here's where I am and I need some help figuring out how to answer this. That doesn't have to be a huge, huge legal bill for you. That can be something you can say, look, this is pretty directed. I need to know what I can do in this circumstance. And there are resources out there. I still do that. I have a standing call with Hudson Cook. There are lots of things I don't know, and they're experts. So I reach out to them and say, hey, help me with this. And so you just have to have resources across the board that can be there for you when you have something that, you know, a fire that comes up that you need to put out and you've never seen before. Because they'll happen. They happen to us still. So it's not anything new.
As far as a shout out, Shawn Peterson may have already ducked out of here, but Shawn's a great resource, and he's your resource. As members of this organization, if you get stumped, call Shawn. He might not be able to answer your question, just as none of us can necessarily answer your question. But the best lawyers are the ones who say, I don't know, but let me find the person who does. And Shawn's a great one, and everyone in here has his number, I think, available to him.
Or the attorney for your state, you know, NABD. So some are more active than others, right? Are going to have more, like obviously Florida has a pretty robust support system, but don't be afraid to reach out to your organization. That's what you guys are here for. That's what you get from the organization.
And I really think by taking the proactive approach to compliance, you'll realize in many instances where some gaps are, and maybe you'll be able to reach out to either a lawyer or, you know, in some instances there's dealership consultants and people that will help with the business that are more familiar with this stuff, and they will be able to help you out. But once you kind of take that proactive approach to compliance, you'll be amazed at the number of things that start popping up, whether it's a little article like cooperating with the regulators to getting on the email lists where new things or changes to statutes will come out. You know, there's changes to the law all the time, and not staying up to date on those changes, it can be extremely problematic. Somebody mentioned here the statutes and regulations that deal with the automotive industry. A couple of years ago at the Florida Independent Auto Dealers Conference, I put together kind of a desk reference of commonly referenced statutes in Florida that impact the dealer's business, and it was about that thick. There are so many layers to regulating both the dealership side and especially if you're doing the finance side as well, because now there's a laundry list of federal regulations, there's federal statutes, state-specific regulations and statutes, and you know, you run into issues. I mean, if a customer moves to another state, whose state's laws apply? I mean, you know, you're going to run into these questions, and without dealing with them on the front end with compliance, you can really end up in a hole with our next topic, which is litigation. And Evan, do you have something?
I'm just curious, is anyone here from North Carolina? Y'all have you have a real fun set of collection laws there. So, like you said, every state law is different, and
yeah, Florida does too. Florida has crazy collections laws, and you know, and some judges are interpreting them in crazy ways. If a customer says they can't pay, Florida says there's a presumption, well, at least some of the judges say there's a presumption that calls after that are harassing as a matter of law. Now, I disagree with that, because if a customer says I can't pay because I lost my job, I think at some point you can call them back and say, did you find a job yet? Now, maybe it's not the next day, but certainly a couple of weeks later, it would be reasonable to reach back out to somebody. So little nuances to your own state's collections laws or your own state's requirements when dealing with customers can really help you avoid the litigation aspect.
Hey, Rob, before we switch off to litigation,
Yeah.
can we talk complaints?
Yeah.
Because I think
Sure.
complaints is a critical one. I just don't want folks to leave in the room. And we've talked about this a lot, but One thing, I know we've got a wide variety of dealers in here, from smaller to middle to larger. And I would really challenge everybody that if you're not tracking your customer complaints, that you should be. And you'll hear that there are things called CMSs and these elaborate programs and systems that you can implement to track them. I will absolutely tell you and confess to these guys, just like I did earlier, we track it on an Excel spreadsheet. And so there's no magic to how you do that, but it should be a centralized place that you're tracking your complaints from your customers, so that you can demonstrate to a regulator that you do take those seriously and that you're trying to address them. It'll also give you the opportunity to then analyze, like, where are my customers, where are the problems, right? Is this a unique collector that's having a specific issues, and is there room for improvement there? But understand, from the regulator side, that is an expectation now. And so if you're not tracking your customer complaints, you should be.
When we started doing complaint tracking, we used legal pads. So don't be afraid to go analog on this. It doesn't have to be a huge software solution. We've since evolved, but someone has someone call in and they're ticked off, or a customer comes in, they're ticked off. That's an opportunity. We look at it as an opportunity to make our business better, right? We can be serving that customer better, perhaps. We can be offering a little bit more support for that customer, whatever it is. It's an insight into our business. So we want to know what those are. And don't be afraid, just write it down on a piece of paper and collect them and review them at the end of the month and put in a spreadsheet, 5 complaints and they seem to be about this topic. You can start really, really, really low key on that. So don't be intimidated that it has to be a huge project that you bite off. And in that vein, I'm going to double back just a little bit on some of the compliance stuff and give you a little bit of the not scary perspective, which is that you can do it. It doesn't have, you have to think that it's scaled to your size and your scope, right? So if you are a one rooftop operation and you're moving a few cars a month, your policies and what you're doing, your compliance system should be matched up with that, right? So it's going to be smaller. It's not going to be the 30-page policy or manual that we're talking about. And it could be as simple as, I looked at what the rule is and I wrote down what I'm doing to follow that rule, right? And I think everybody in this room can start there with something, right? So think about that. I would say the best thing to do I would imagine a lot of people here are sort of in the beginning stages or intermediate stages of building compliance, right?
I think everybody's always,
yeah,
sort of like,
yeah, we are. If you guys are
it's
past that, I need to know what you're doing.
Yeah.
But look at your risks. I would say look at your biggest risk areas and then start there. So like I was saying, I think TCPA is a big one of those that perhaps is a higher risk, and start there. Write your TCPA policy. You've got one done.
Yeah, one of the questions you were gonna ask is how many folks in here are reporting credit?
How many of you guys are doing credit reporting? Don't be afraid. Woo. Wait, what did you say? 20%?
I said 20%.
He owes me a drink.
I apologize.
Thank you. I paid them all day. So obviously, credit reporting is a complicated, labyrinthian world, right? But it is one of the very few areas where you have to have a written policy, right? That's not a choice. So look at the FCRA, the Fair Credit Reporting Act. Get some help. There are examples of policies out there. Talk with each other. What are you doing? Talk about how you're reporting information, how you're making sure your information is accurate, how you're handling when customers dispute information. Just write it down. Put that on paper, and there you go. You guys are doing it. You're getting that policy off the ground, and then, like Clay said, follow your policy. And then don't be afraid to get something on paper and then refine it and learn more and go to conferences and learn more about credit reporting and then refine it from there. But just get that on paper, and you're going to feel like, yeah, I got that done. I'm getting this started. And so just start with your higher risk areas. Credit reporting, TCPA is one of them. You already talked about buyer's guides. Red flags, advertising. I think advertising that's a great one to start writing a policy for, because you look at, if you're in leasing like we are, we look at the CLA, Reg M, and you guys would look at TILA and Reg Z if that's what you're doing. Look at the triggering terms, right? If my advertising has a down payment in it or APR, then you have to have certain disclosures. Your policy can say, here's what the law says, and when we have these triggering terms, we put these disclosures in our advertising. There you go, you're writing your advertising policy.
Well, and the FTC has some free resources available on their website regarding advertising for dealers. I mean, they'll give you what you need to do, what needs to be in the ads, how they have to be phrased, what you can and can't say. And they've got a publication, it's a little bit more robust and complicated, but they have what's called .com disclosures that talks about if you're doing any internet advertising, you need to have certain things. For example, if you've got an ad on your phone and you've got disclaimers that only appear on the desktop site, they also have to be viewable by a phone. And if somebody could have a 10-year-old smartphone and theoretically under the FTC's requirements, your website is supposed to be able to be viewed on that phone with the disclaimers that appear online. So links sometimes don't work the same way. Sometimes the text is hidden, and all of that falls on the dealer. So the FTC, again, their website's a pretty good starting point for those kinds of policies.
Well, again, everything I hear on this panel, it reminds you of, these are all best practices. Everyone in here is trying to sharpen their game. We all practice law. We are practicing it, trying to get better at it every single day. Y'all are in the business of selling cars. You're getting better at it every day, but yes, you do. You're putting it in action more than we are. I mean, every single day you're making contracts. I remember when I left private practice and came in, I sat down with one of the principals and I said, every lawyer fancies themselves a deal maker, particularly when you've tried cases and you've settled cases. And I realized you've done thousands more deals than I have. Every single day you guys are doing deals, contract after contract. It's nice for us to check the contracts every once in a while. But that goes into having a written policy. You're auditing your deals. You're making sure all the I's, there are dots above the I's and the T's are crossed. But that's a written policy that we have actually. And always remember that faintest written policy.
You say you have a written policy that says all your I's are dotted and your T's are crossed?
No, we have a written policy to audit deals in which I am looking for dotted I's. And cross T's and commas. That once you have that written policy, it's a whole lot better than, our policy is. Because the faintest ink is better than the sharpest memory. Once you've got it written down, that's it. And then you walk the walk to avoid lawsuits.
Well, you guys mentioned the complaint log, and I think it's interesting because have you had or experienced any issues with this complaint log where, you've got essentially a laundry list of complaints from customers now, and someone takes that, whether it be a regulator or somebody in litigation tries to use it against you and say, well, you knew that sales guy Joe Smith did this bad thing back here when this customer complained about him. Now, it goes to reason that you would have to have some kind of a discussion with him or investigate it once it's in the complaint log. But have you experienced that, and if so, how do you deal with that?
Yes, well, so I can handle that from the regulator side, right? So we deal with our friends at the CFPB or the BCFP, whatever they're called now. Again, their expectation is you do have this. So if you don't have it, you're going to have a more hostile discussion. The flip side is now you have it. You've got a laundry list of hundreds of complaints. What do you do with it, right? So some key tips on that list is be careful what you're putting in there, right? Don't train your folks in not using legal conclusions like,
customer signature was forged.
Yeah, or this was fraudulent, or they represented these kinds. Just use the facts. Put facts in there. We find it to be helpful, and then we're going to put it in perspective always, right? So I may have a tracker that has 100 complaints on it, but I'm going to put that in the perspective of I've sold 150,000 cars and I'm servicing $4 billion in debt. So I mean, you put it in the perspective of what it is, and that relates down to whatever size dealership you are. So your scalability goes down, and if that's 1%. Then you can tell a better narrative around that. And you are better served having that list than not having that list.
And that you're doing something about it.
Yeah.
You know, I think we have board meetings, we have compliance discussions in our board meetings, and what I do is I report and say, here's our trending on our complaints, and sometimes there's something we can do about it, and sometimes we're not doing anything wrong, and we decide, you know, we're upsetting customers, so we're going to change what we're doing. And sometimes we have a discussion that says, well, we've at least looked at this. We've taken into consideration that it's upsetting some people, but there's nothing that we can do differently. So, you know, we have a business reason for this, and we move on. And being able to show that you're at least having that discussion, right? So if you're getting a couple complaints a month and you're looking at these quarterly, you can say, hey, look, so-and-so seems to be telling customers this thing. Okay, well, go talk to that person. You've remediated that issue, you know, and document it. Write a page up that says that you did that and put it in your complaint file. And there you go. You can show a regulator or anyone that comes in that you're taking that to heart and it's actually affecting what you do. And I think that also complaints are a compliance issue, but also very much a litigation issue, right? So it's going to help you avoid litigation because you know what's ticking off your customers, and you can maybe make them happy before they come make you really unhappy.
Well, and that was kind of our next topic, which was, you know, complaints come in many different ways. You can get a customer that calls in, you can get a letter or an email from a customer, you can get a letter or an email from a lawyer, and you can get a lawsuit or an arbitration demand. If you could talk about the way that you guys deal with the complaints and if there's any difference as far as what type of complaint it is and kind of your process for dealing with that. And then if there is a difference, if we could focus more on the litigation process and what happens when you get in a lawsuit or a demand letter from a lawyer and how you deal with that and you know, kind of your steps in that process. And Evan, we can start with you.
Sure. Well, you know, and again, listening to what's being said up here, your complaint management log it should be the canary in the coal mine. You should know, they're your customers. You should know when your customers are upset. Every lawsuit it's a customer problem. It's a customer service problem. Maybe it's their unreasonable expectations. That could be the problem. But you have an opportunity to address it before it becomes out of hand. Because once a lawyer is involved, they're expecting a fee. They're expecting a fee. So our process is any communication coming in from a lawyer, I'm at least alerted about it. Sometimes, you know, bankruptcies, you know, that's a litigated matter. Whether you think about it or not, your deal just got changed by the judge. So I like to be aware of any litigated matters, and I immediately notify our IT, because that I know Clay was even saying particularly is the nature of lawsuits have changed. They want your cell phone records. They want your texts. They want your emails if you're going to be in a lawsuit. Clay and I participated in an NADC meeting the other day where one of the largest national RV dealers out of Florida, he contracted for it, where he requires pre-suit mediation. And mediation's a voluntary, can we solve this problem? Me, or you know, the dealership sitting across the table from the customer, what are your concerns? Here's where we think we are on this. He has, I think he claimed a 95 or 90% success rate in getting those claims shut down. I'm pretty proud of the fact that our organization doesn't see many lawsuits. I've tried plenty of lawsuits. I don't try many now. We don't see many lawsuits, but obviously if there is a lawsuit, don't wing it. If most of you are corporate entities can't appear in court by themselves. They must be represented by an attorney. Again, fostering a relationship with an attorney throughout the year may cost you what it costs you to come here. But that attorney then knows your business on a regular basis. And if you get a lawsuit or you know, you've got to get with your attorneys. As far as our handling of that, I've been able, the claims that I have not, usually I've not seen them before a lawsuit was filed. And when they're filed, again, you sit down with the customer, even with an attorney on the other side, and reach an amicable solution.
Yeah, I would just say we actually see most of our lawsuits before they're filed, right? And I don't mean the actual lawsuits, but we see the complaint. We see the attorney letter. We see all of those things. We're given multiple opportunities to engage. And so I am all for, and particularly at the front end of those, as those initially come in, we have a customer, dispute group that is trained to resolve those. I'm all for getting our business folks, if I were in your shoes as a dealer, I would be all for having my business folks engage with that customer to solve that customer service issue, right? We all know that customers are not always right, and their expectations, as Evan noted, are sometimes completely unreasonable. And so you're not going to be able to eliminate every issue. But 95% of the complaints and problems that come up as threatened lawsuits, you're absolutely able to resolve, and you should be, spending your time to resolve, because Rob is very good at what he does, but Rob is also very expensive. So,
He's a
I'm
bargain.
not that expensive.
that's right.
And I always tell clients it's never cheaper to resolve a litigation matter than the day it comes in.
Yep.
And that's just from your own time, from the amount you're going to have to pay a lawyer to review it and look at it, to what the settlement expectations are going to be. Because many of the consumer claims contain an attorney's fee provision that awards fees at the end of the prevailing party, or in some instances only to the plaintiff if they prevail. And under those circumstances, every hour, every day that file exists, that lawyer is doing stuff on, he's going to expect to be compensated at some level. So eliminating that early, even if you maybe overpay on the claim, it's really a $1,000 claim, but they want $2,000, it's probably going to be cheaper to resolve that claim there. Now, if the guy keeps coming back, if he becomes what I call a frequent flyer, is suing you or making claims against you every month, then at that point you've got to pick a case to fight, but make sure it's the right case. The worst thing you can do is pick a case to fight about and then lose. Because if you pick the wrong one to fight, you're going to pay damages, you're going to pay attorney's fees, and you're going to have spent a lot of time, and you really didn't send the message to the lawyer that you were trying to send, which is, if I think I'm right, I'm going to fight about this. And we've got about 5 more minutes, and I want to leave some time for questions. So one of the other things that we talked about was the arbitration versus litigation issue, because that's a frequently discussed issue. Arbitration clauses are helpful to avoid class actions. They're really useful for that, but many times an arbitration situation is more expensive from the dealer's standpoint than going to court, because if you want to get in front of AAA, if AAA is the arbitration forum in your arbitration agreement, there's about a $4,000 fee to get through the front door with AAA. So many plaintiffs' lawyers view that as a ticket to get at least $3,000 or $2,000 in a settlement on the front end, because it's going to cost you $4,000 to go to arbitration. So I would open it up to the panel as far as your thoughts, arbitration versus litigation, pros and cons of each, and anything you guys think about on that topic.
Well, we don't go to arbitration or have litigation because we make our customers happy. No, but honestly, speaking to what both of the guys were talking about, it's been a big lesson for me to learn, but I've sat in meetings with my boss and a disgruntled customer, and I know that we're right. I know that they don't have a leg to stand on. I know that we're doing the best that we can, and we're not trying to, fleece them or whatever it is they think that we're doing. And I've seen him say, okay, what do you want? Okay, write a check, draft up a settlement agreement is what I hear. And I walk out and I want to grit my teeth. I'm like, why did you do that? We didn't need to do that. That we weren't wrong. And he's smart enough and been around long enough that he said, it's not worth it. I've learned it's just not worth my time. It's not going to be worth it. And you're never, ever, you're always going to be the big bad guy, no matter how small you are. Right? You have to think about what that's going to look like. You're always going to look like the big bad business person who's fleecing customers, right? So it's, for us, we just work so hard to get things to a point where we never, we've gone to arbitration once in all the years that we've had an arbitration agreement, and I can count on one hand how many suits we've had filed against us in the past 4.5 years. Now we do litigation on our own deficiency balances, and we'll get cross claims or counter claims, right? And we pretty easily dispense with those too, because usually there's not a whole lot there, and if there is something there, well, we should get rid of it anyway. So those are pretty easy to get rid of. But my best advice is just don't let it happen. Bite the bullet, swallow your ego, and write a check and walk away, because you're gonna be grateful you did that later.
So now let me give the other point of that, which is you're going to end up in lawsuits or arbitrations. But for this group, what I would really strongly consider is it's not an easy decision to say, yes, we should have arbitration or we shouldn't. If you go to arbitration, Rob made some excellent points. It can be more expensive. But the other thing is there's hopefully not public filing. It's not a public record of the outcome of those findings. What I would say, though, is if you don't use arbitration, please really strongly consider a jury waiver and a class waiver. There is a split on the law in circuits on whether class waivers outside of arbitration, whether they're enforceable. So just know that that's not a particularly clear or settled legal issue. And so if you put a class waiver in there saying you can't bring a class action, that may or may not ultimately be enforceable depending on where you live. And that's a significant issue that you could end up facing.
And again, y'all missed a great discussion earlier. But, you know, the American Arbitration Association, the AAA, it is extremely expensive. And I think when the first time I was called upon by my client to enforce it, I was still in private practice. And I said, let's not go to the AAA. It's just too expensive. And Rob, you have a great solution, which is it's a contract. You can agree on the front end, and we do follow the AAA rules, but you can agree that an arbitrator can be a retired attorney, a respected, a retired judge, an attorney on the panel of alternative dispute resolution with the state that you live in, and then you're paying one attorney's hourly rate. You can go in there, and that person is the trier of fact. You can create in your contract whether or not that's final, how the fees are paid. I like arbitration for the class action waiver, just because the class action thing is you're trying to do the right thing. Again, you're human beings and you run a business, and if you make a mistake, a technical mistake, well, somebody wants to try to gig you on that and file a class, even though you may have stopped the process, fixed the problem. Class action can just finish you. So the class action waiver is pretty important. And as Clay indicated, when class action waivers and arbitration are tied together, it's a good defense.
Okay. We're almost out of time, if not out of time. Are there any questions for the panel while we got everybody up here? It's a good opportunity to ask some in-house lawyers their thoughts on whatever issues you might be experiencing. Yes?
I think it's by state.
Yeah, it definitely varies state by state, and so you got to know some states have rate caps, some don't. And you definitely have to know state by state. You need to know whether motor vehicles are included in your usury laws or whether they're carved out. But unfortunately, we're going to give you the lawyerly answer of it depends, right? Unfortunately, but depending on your state, it absolutely varies state by state.
We do have an answer. The answer is yes, there are rules. It's up to you. No, it's state by state, so impossible for us to answer all of those.
Yes, sir.
You have an arbitration agreement with somebody and they end up not showing up for arbitration. Is there some way of getting a default judgment or something through that the same way as if you run a report and they didn't show up?
I don't know why you couldn't. I mean,
Yes,
the arbitrator, I mean, we're deciding the case on this date in this place, and if they don't show, well, then I'm ready. You know, that's the same thing. Sometimes, I'm sure some of you have taken a default judgment against someone who owes you money. I'm ready for trial. I'm ready to arbitrate, and the other side isn't. I'm ready. I win.
If it's a collection action,
Earlier on in there, if they didn't bother responding to the arbitrator or the
Yes.
ultimate date or any of that kind of stuff.
Yeah, because we just had this 2 weeks ago. So yeah, the answer is absolutely you can, and then you can take that judgment and you can go enforce it in an actual court of law, and you can go seek to have it enforced and start doing your garnishments and all of your other withholdings and everything else.
if it's a collection action, sometimes arbitrators are reluctant to enter a default right away, or to tell somebody that they can't proceed, so they'll reschedule once, because the National Arbitration Forum was an arbitration group in Minnesota that got in trouble a few years ago because of credit card collection lawsuits and what was happening. And there was this study done, and the percentages were all off, but I don't know how many collection actions in state court a consumer wins, but they said there was like a 96% loss rate. So I know from experience arbitrators sometimes are reluctant to enter a default right away, but eventually they will, and they should. Was there another question over there?
Yeah, can you give us some examples of why a regulator
Customer complaint
Yeah,
would be number
the
one.
answer is customer complaint. And they will tell you, no, we're just here for a routine audit. It's not related to a specific customer complaint. Anytime someone tells you it's not related to a specific customer complaint, you should always say it's most likely related to a specific customer complaint.
But magically, they've got a list of 10 deals
Yes.
they want to see,
Yeah.
and they're saying, well, no, it's not specific, but we'd like to see these 10 deals. Well,
Yeah.
you know, that's a red flag.
As far as recent enforcement actions, I think the FTC just,
They do stings.
yeah, I think they just took some pretty stiff action, mainly related to advertising.
But almost all of those come from
Someone
a complaint. I want to say just a customer. It can be a competitor complaint. It can, I mean, and that's the unfortunate thing, right? It can be a valid complaint, or it could be your competitor across the street that just is trying to jam you up and files a complaint. We've seen that. So.
Well, internet advertising exists forever. I mean,
Yeah.
and I can look at it anywhere. I can pull up your ad right here from this conference room and determine whether it's compliant or not from, you know, my seat in my office. So regulators are very easy to, it's very easy for regulators to access your online advertising and things like that, and they can review it at their leisure and then see where the holes are and where they think you have liability, and that can trigger, you know, some type of an enforcement action.
Well, and there's a record retention requirement for advertising, so you're supposed to keep them around for a certain amount of time, right? And so they can get a look at all of it if they don't like what you're doing today, so.
Yes.
It's not gone.
Nothing goes away on the internet.
It's the Wayback Machine, and I can see your price. So if you have your internet price that changes upward sometimes, I mean, they can. There's more of an investment made. You know, you can have somebody call. Through the finance company, we had a dealer we had to have that conversation with of, hey, your advertising one price means you need to keep it at that price or change it. But it's there.
Everybody's going to claim it's a finance charge. If you've got an internet price of $12,000 and the person contracts at 13, they're going to say it's a finance charge.
Yeah.
And if your ad says you must mention the ad to get the internet price, it's uncanny. Every case I've ever had, the customers always mention the ad, every single time.
Yeah.
They've said, oh, I wanted $12,000, but they told me they couldn't sell it to me for that. And then by then, they've talked to a lawyer. The lawyer may or may not have told them that if they say they asked for 12 but got 13, they can get money. So having multiple different prices, I think, just creates a huge issue for lawyers from a risk management perspective. It's not illegal.
In some states, it's illegal.
Oh, well,
Yeah. So just be careful. Just be very careful.
Any other? Yes.
Regarding tracking complaints, I started tracking complaints about a year and a half ago. And we have 4 rooftops, and I found it logistically somewhat difficult. But the biggest issue I ran into is, where do I draw the line? Is there a line to draw? Do I really need to log every person, whoever showed up or caught up and said the brakes are squeaking, and you know, we made an appointment to put brakes on our car? Where is there a line, and if there is any idea where it is?
Yeah, the answer is there's not a bright line test out there, and I've had this exact conversation with my friends at the CFPB or BCFP about this exact thing. I will just tell you where we draw the line, which is if a customer calls in with a issue, concern, complaint, and we're able to resolve it on that phone call, we don't track that. Because we don't view that, I don't view that as a complaint. I view that as our customer service doing what they're supposed to do. If it gets escalated beyond that, we escalate it and we do track it from there.
So, yeah. I might want to include that, though, because if you include it, now it's a resolved complaint.
Yep.
So you can show 99% of your complaints are resolved. We fixed our brakes. I mean, you know, so maybe you do want to track that.
So we take that approach. So, you know, Clay and I were having this discussion earlier. We're more interested, like I was saying, in finding out how we can serve our customers better. So we view that as a data point that's going to tell us a particular practice or product is upsetting a customer. So we spent probably 9 months as an organization trying to figure out the definition of a complaint. So it's not easy. I understand. I mean, we had board meetings where I said, can we please not talk about the definition of a complaint again? And it comes down to essentially, do you want to capture that information or do you not? Whether you call it a complaint or call it a gripe or you call it expression of dissatisfaction or whatever it is you call it, if you want to track that because there's value in it for you, then do it. But if it is something that needs to be escalated and remediated and perhaps there's been some sort of failure in your system, I think probably that's definitely going to rise to a complaint. That's something you have to track. But only you can answer below that whether you want to know every time someone calls in because they're hearing a rattle with their car, or, you know, for us, some of that we like to track because that helps us understand what models are having problems and how soon are they having issues. And, you know, it gives us more data points to work from. That might be too cumbersome, and you might say, you know what, no, only if it gets escalated. But then make sure you are tracking those and addressing them.
Yeah, one thing I would just want to note for the group, we talked about this before, but on your tracking your complaints, if you do have that escalation point, I would try and have it to be a somewhat independent or removed person. So if you've got your salesman who sold the car and the complaint comes to them and they don't resolve it, like I would have that escalation point be someone other than the salesman, right? It needs to be someone that's outside that chain if you can. Yep. Right.
Yeah.
So I guess for me, the line would be when customers no longer happy with that person.
Right. And then when it goes to your escalated point, they keep the tracker, and that's kind of the way we operate it.
After me.
Oh, there's one more?
Regarding late fees, is it typical for those to be considered a finance charge that would need to be disclosed as an interest rate on a contract?
Well,
I'm not assuming my customer is going to pay late.
Right.
I assume my customer is going to comply with the contract, so they'll never have a late fee. So why would I put it in the APR? But I mean, I can certainly see a plaintiff's lawyer making that argument, but I don't think it's not in my mind, thankfully.
Yeah, I mean, our answer would be
yeah,
no.
I mean, the APR is just the cost of credit, assuming all payments are made on the scheduled date. No different than additional interest would accumulate if they paid 3 days late. You know, your APR doesn't have to account for that because you assume all payments are made in accordance with the schedule.
Yeah, no different than a repo fee. You know, all the fees that happen if the customer does or does not do something.
Now, it would have to be in the contract because you've got to have some explanation as to what it would be.
Yep.
And there are some state caps on that, but I don't think it impacts APR.
Yep.
Is there one more question over there? Because I know we're running out of time.
They're dropping like flies.
It's in fairness, it's lunch for overtime.
I mean, yeah, that's not enough.
Yeah, to do what? To sell a car online? To sell?
For advertising or?
To advertise, okay.
You're putting a full TILA, okay.
Wait, you're talking about what advertising disclosures are required
You're
with
just
that?
advertising $200 a month plus $500 down?
Yes,
You need the
'cause
price of the vehicle.
Yeah, you're going to have more terms.
Yeah, you've got to have
There-
additional terms in there.
the down payment amount is what's considered a triggering term. And if you have that in there, I think APR, we do leasing, so I'm not 100% sure exactly with TILA, but yeah, APR, down payment, there are a few in there that, and these are easy for you to find. This is one of those that, like I said, is going to be easy for you to write your policy because you can find this information. What are the triggering terms? And then it's very clear, if you have these terms, you also have to say these other things. Yeah. And it has to be clear and conspicuous. It can't be the little blah, 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 if it's a radio or TV ad. And
Hyperlink in white.
Yeah, and it can't be the, you know, you've seen it where you pause it and you can't read it. So make sure it's something, it needs to be more information, not something that's completely goes against everything else you've said in your advertisement, right? It's basically, here's more information that you can easily read.
Yeah, and actually the FTC does, that's their online,
Yeah,
that online advertising guide, which is free, they have a pretty decent explanation.
And they have
Yeah, it's got samples and everything.
Mm-hmm.
It's basically cut and paste. That's what you'll have to use. I mean, they make it.
And states may have
They make it
additional
easy
requirements.
and painless or painful all at
Yeah.
the same time,
Like
right?
And
typically
there
in
are
Florida,
state
if you're
requirements.
advertising a vehicle, you've got to include some identifying information about the vehicle, like a VIN or
VIN,
whatever, if you're
yeah.
advertising a price. So again, your state may be specific. All right, well, that's all the time we have. I'd like to thank
Thanks for sticking
Tiffany, Evan, and Clay for coming in and sharing their insights today.
Yes.